Good morning, or good afternoon, I should say, everybody. My name is Chris Justice. I'm an employment lawyer with Samfiru, Tumarkin. And I'm here today, as always, to hopefully answer as many questions as I can, all things employment law related. So if you're in an employment situation, you're trying to figure something out, maybe something's happened, get your questions in, and I'll do my best, as I say today, to answer as many as I can. I do want to start off with the topic before some of the questions come in about performance improvement plans known as PIPs. I was actually just on a call with a client earlier this morning, and this was a situation that had come up where he had been working for the company for a while, and then somewhat out of the blue, he gets told that his performance is not up to par from the company's standpoint, and they issue him a PIP, a performance improvement plan. And in the PIP, they basically say that his performance is slacking and that he needs to do better and sell a certain amount of product within a certain amount of time. And the company had sort of put in place all these goals and objectives that they wanted him to reach. But after speaking with him, it became very clear that the goals and the objectives were not or are not realistic. And even further to that, they were expecting him to reach these goals within about a month's time, which also related to the unrealistic nature of the goals that it had set to begin with. And so one of the things that happens is, in these PIPs, employees are told, you need to do this, this, and this by this day. And it's one thing if what's being asked of the person is achievable, if it's realistic, if they can get that within the time that they're being given. But it's an entirely different thing where the time frame they're being given is very low. The objectives they're being asked or told to meet are very high. And so what I told this individual was that they needed to respond to this PIP, this performance improvement plan, in writing and address the concerns they have about the PIP. And one of those concerns was the realistic nature of reaching those goals that the company had set out. So I told him that, you have to identify what it is about these objectives that's unrealistic. So that was one thing. But there's also a common issue in PIPs where when you read the PIP, it will kind of go through a number of criticisms that the company has with the employee's performance. So in this particular guy's case, not only were the objectives and the goals set by the company unrealistic and not achievable in such a short amount of time, but the actual criticisms, the concerns that the company had or has with this employee's performance, when I spoke to him, he said that some of what they were saying wasn't even true. So they were basically criticizing him for things that had not happened. And so that's another reason to push back and put in writing any inaccuracies in the letter. So number one, if the goals are unrealistic, you want to establish the basis for that. Number two, if some of what's set out in the PIP is just factually not the case, then you want to clarify that in a response. And then a third thing that came up was when it came to the performance improvement plan, some of the context had been taken out of the situation. So, for example, it was saying, we want you to do this, this, and this by this time because we don't think you're doing enough right now. But then they completely failed to mention the fact that a majority, or at least a large part of this person's time in the workplace was spent on doing things that are unrelated to the PIP altogether. And so one of the issues was, well, I'm spending, say, 20 hours a week doing this stuff over here. You're telling me to do this stuff over here, but now you're saying I need to do 2 or 3 times as much work on this other stuff that's mentioned in the PIP. Well, there's only so many hours in the day that I have, and I have a big workload. I've got a lot on my plate. I'm doing this, this, and this. So if you want me to do the stuff over here, you may have to take away some of the things on this side because, again, there's only so many hours in the day, and it also goes towards the realistic nature of completing the goals. So there's a number of different ways that people can take issue or I guess respond to a PIP as far as maybe what's in it being inaccurate. And as an employee, you just want to make sure that you do put this in writing, whether it's just something factually not the case, or they're taking a lot of the context away from the situation, or they're not really supporting you in the way that you need to achieve these goals. Because a fourth thing could be, they want you to do this, this, and this, but they're not really setting you up for success. Maybe they're not offering any guidance or suggestion on how to achieve the goals that they want you to achieve. And they're just expecting you to figure it out on your own without any input from the company. That's another criticism that I often see with performance improvement plans, where they'll say, we want you to do this, this, and this, but then they give no guidance. They give no support. There's a lack of resources. And so that kind of ties the hands of the employee, because even if they wanted to, they can't get that done because the employer is not providing that kind of guidance or support. So it goes both ways. I mean, the parties are supposed to work together to come up with solutions. But if your employer is not offering any solutions and just telling you to do better, then that's going to be another issue with a lot of PIPs and another reason why you should respond. And you want to respond in writing specifically, because if you say it in sort of a meeting or verbally, there's no guarantee that the company is going to agree that those discussions were had. And you could find yourself in a situation later on down the road where the company, they're denying what was said or discussed in a meeting, which is why there's the importance placed on putting things in writing. Because then you create a record, you create a paper trail. And if your pushback to the PIP or your concerns with the PIP are put in writing, and they're all valid concerns, and they kind of highlight the unreasonableness of the PIP, then the employer is going to be less likely to be able to rely on that PIP later on to maybe let you go or terminate you for cause, even worse, and try to avoid paying you severance. So you want to kind of protect yourself for things like that in the future, but also just in general, make a record and notes of discussions that are had around the concerns with the PIP. If you don't put your concerns in writing, then there's a possibility that you'll be seen as having agreed to the PIP, agreed to the performance improvement plan, and basically agreed to the company's view as far as your employment there and your performance of your job, which if you're taking a big issue with, obviously you don't want that to be reflected or that to be the case, which is again why all the more reason to put your concerns in writing so that there is that record and so that you've done what you can do. And then at that point, once you've done that, then the ball is going to probably be in the company's court to decide, do they agree to the concerns or the pushback? Do they still insist that this PIP go forward? Do they kind of brush aside your concerns? Because that all could hurt them as well. So if you're in a situation like that, those are just some of the key things to be mindful of. But, as always, give us a shout. We can set up a time to chat and just make sure that you're saying the things you need to say, that you're communicating what you need to with the employer, so that you're at least providing yourself with that protection should the worst case scenario happen, and basically go from there. But with that said, I'll get into some of the questions. So I've got a question from Kenoki, who's saying they're in BC, non-unionized public sector clerk. Medical leave ends on December 10. How soon do I need to submit the doctor note for an extension to the employer? I would say just in general, the sooner you can do it, the better. There's no bright sort of line or exact science on when you should do it, but I always just say you consult with the doctor. If the doctor determines at a certain point that the leave needs to be extended, could be for a specific time frame, or it might be somewhat unknown at that point, then get the extension in. So that would be my answer there, Kenneki. I've got another one in from Simone on Facebook, who is saying or asking whether an employer can force you to use your vacation days while you're off recovering from surgery, even if you provided a doctor's note. And generally, the answer to that is no. Certainly, if you're on a medical leave of absence and you're not getting paid, it's an unpaid leave, there's an option to use vacation days just to provide you with some money, some payment in the meantime, there can be, I guess, a negotiation or something done between you and your company. But an employer can't otherwise generally force you to use your vacation days, especially if you've got the note from a doctor supporting your leave. Again, you're not technically on a vacation at that point. So to have them do that could be running afoul of the legislation. There could be a violation potentially there. But whether it's Simone or someone else in a situation like that, again, give us a shout and we can kind of walk you through what you need to do to protect yourself moving forward. I've got another one in a comment or a question from Jackie, who's saying, large company, your firm is dedicated page that is letting go of 11,000 employees with severance. There's another comment. I work for a large company. Your firm has dedicated page is letting go 11,000. Been Ontario 7+ years as a senior analyst, age 40s, terminated the cause, effective December 5th. So it looks like they're giving you about a little over a month's worth of notice. And I guess the question is, after December 5th, are they offering a package? And I see another comment here. They're offering 14.17 weeks of pay, vacation and benefits to January 23rd. That's about it looks like. So, there for 7 years, they're offering you about 14 weeks of pay. It looks like what they're offering you is the bare minimum in terms of what you're owed under the Ontario legislation. That's the bare minimum. So as a 7+ year senior analyst in their 40s who's let go, you could be getting 10 months or more potentially of severance if we look at your absolute best case scenario. So the fact that they've only offered 14 weeks, which would be roughly a little over 3 months, is obviously a far cry from what your potential is. Now, it's quite possible that you may have signed a contract, some sort of employment agreement that could limit your potential. But most of the time, there isn't something like that in existence. I see, Jackie, you're saying there is a contract. It does mention ESA minimums, common law not being allowed. But I doubt that's the reality. And I think I probably agree with you. Even if there is a contract that you've signed that mentions, if we let you go, we're only going to give you the bare minimum and you're not going to be entitled to anything more. A lot of people might think, I'm dead to rights. I don't have any ability to get more than this minimum. But I would say probably 90% of the time, I look at these contracts, I look at the language in the contract specifically, and from a technical legal perspective, I find that the contract is not worded how it should be, which ultimately would benefit you. So I would never assume that just because you've signed something, like you say, that is the reality. I think there's a very good chance that the contract is not going to give the company the help that it wants in limiting your rights. And for that reason, I definitely have you give us a call. I'd ask that you give us a shout. We can set up a consult because, as I say, even if you don't get your best case scenario, but you get 6, 7, 8, 9 months, that's still going to be double, if not more, than what you're being offered now. So yeah, definitely give us a shout. Don't sign any sort of release or any severance package, because once you do, then it's going to be next to impossible, if not impossible, to go back and reverse that. So give us a shout, and we can definitely take you through that. And I noticed you did say something about a bad faith claim, denying reemployment, I guess, internally. I don't know if that would be bad faith. It's unfortunate, but I don't think once a company has let you go, or in any event has an obligation, legally speaking, to give you another role within the organization itself, even though you're qualified. So maybe while not being in the best interest of the company to do that, not necessarily bad faith, unless you can show that you were denied that opportunity, let's say, for example, on a human rights related ground. A lot of times easier said than done, of course. So it's possible there could be bad faith, but if it's just, we just don't want to have you in that role, nothing to do with human rights, we just prefer it, someone else in the role maybe, then there's probably not a whole lot you can do that. But yeah, definitely give us a shout. I see you submitted the form on our site this morning. So someone will be in contact. You'll get set up with a lawyer who will, I'm sure, guide you in the right direction that you need to be in. But appreciate your concern and your question, Jackie. I have another question in from Voices, who's saying they're in Quebec. They're on disability since 2021. Benefits were cut by, looks like, the insurer in March of 2022. And they've been diagnosed with ADHD, ASD. Aside from the union, they're looking to pursue damages. So it seems like you're unionized. There's not a lot I can do on that front because we don't typically practice or specialize in unionized matters. That would be left up to your union rep. The union rep and your collective bargaining agreement should sort of give you the guidance you need as far as what needs to happen to pursue damages. But if you think that there's been a wrongful dismissal or something along those lines, or maybe even a human rights violation, again, I would start with your union rep. Let them know that you have a grievance, whether it's because you want, say, severance, or it's because maybe you're looking for damages in relation to the disability aspect. But the local rep should have the answers, and the process that you would typically follow to get damages or to present a grievance would be also set out in the collective bargaining agreement. So I'd go there first, and hopefully they can give you the guidance that you need. Got another question in from Brian, who's asking, what happens if your employer lets you go right before end of year compensation and bonus packages? These are performance-based annual amounts. So it's a good question. A lot of times someone might get a bonus, or a bonus might be paid out, let's say in January or February or March, and then they're let go weeks or months just before that payout happens. But then they basically work the full year. They put in their dues, and they're earning, or they've earned that bonus. So in a lot of those cases, you're still entitled to a bonus. Employers cannot sort of avoid their obligations as far as a bonus payment just by letting you go right before the bonus payout happens. It may come down to what's in a contract as well, just like a termination situation. There may be some language around a bonus plan, or the circumstances in which someone might get a bonus or not get a bonus. But in general, you're still going to be owed a bonus if you've essentially earned the bonus, right? Again, you've performed for the majority of the year, if not all of it. And it's just a matter of waiting for the bonus to be paid out. There's nothing more you can really do to get the bonus. It's particularly in cases like those that the courts will typically lean on the side of the employee and give them that bonus, or at least a prorated amount for that bonus. So depending on how big it is, yeah, you definitely don't want to relinquish that. So you want to give us a call as well, and then we can kind of advise you on the likelihood you'll get your bonus, what that amount is, maybe how much work or whatever you may have to do to get there. But yeah, a lot of times companies, as I say, do that and think that they can avoid paying the bonus, and it's just not the case. But I appreciate your question, Brian, sorry. I've got another one in from Brianna, who's saying, what happens if your employer demotes you because you can't afford your role anymore, or they can't afford your role anymore, but they keep hiring other people for positions, or new people for other positions? So in general, employers can't demote you. Even if they say they can't afford it, that's not a valid legal justification for demoting somebody. So if I'm making $50,000 a year and my employer says I can only afford to pay you $30,000, and then they cut my wages, by $20,000 without my consent, not something I agreed with, then even if the company is doing bad financially, even if there's some legitimacy or validity to what they're doing, in the sense that they're not making things up there, it still doesn't typically justify them cutting your pay or demoting you or making any significant change to the terms of your employment. So anytime that happens, where somebody imposes a change on somebody else without their consent, if it's a big enough change, then the person who's being sort of subjected to that, they typically will have the option of either accepting the change, right? And then it's hard to kind of go back after doing that. Or they can take a stand and say, no, that's not something I'm agreeable to. This is a significant change to my employment. And then you could potentially use that in a constructive dismissal claim. So you could treat that change almost like a termination and go after the company for your full severance. But because it's not your standard termination where they come to you and they say, we're letting you go and here's what we're offering, you also want to be a bit careful before you jump the gun, so to speak, and leave or tell them that you've been dismissed. You want to get some advice from us too. And so to that end, I would say Brianna should give us a shout, just so that we can make sure you're saying the right things and kind of papering things as you need to. But yeah, the comment about hiring new people for other positions, again, that can point towards some bad faith. It's not really lining up with what you're being told. So not only could you be potentially entitled to your severance, right, like if you'd been let go, but possibly other damages for bad faith or for lies being told. So there's potentially quite a bit there to work with. And again, all the more reason why you should give us a shout and we can kind of guide you along the way. I've got a question in from Megan, who's saying they've asked for accommodations because of ADHD, and the manager said, rather started excluding them from meetings and told coworkers that they're too high maintenance. Is this considered discrimination? And yes, very well, it could be, right? I mean, you would argue that you have a disability of some degree, you've asked for accommodations, and to be told that you're too high maintenance or that the accommodations are too much and the employer doesn't want to deal with that, then they can be seen as having failed to accommodate a disability. Excluding you from meetings as well, then you start to think, well, if I hadn't brought up the fact that I have this condition, if I didn't bring up the fact that I needed accommodations, would I have been excluded from these meetings, right? So, but for that happening, I would have still been in the meetings. Again, that can point to discrimination on the basis of a disability and most certainly mean discrimination. So that would be a violation of human rights. Human rights are expected to be, obviously complied with by employers across the board. It's part of anyone's contract or implied contract that their human rights need to be respected. So by violating that, they've breached that part of your employment. That too could be a constructive dismissal, just like I was mentioning in the other person's question, just a different form of constructive dismissal, but also, of course, involve human rights discrimination. Could be damages for human rights discrimination on top of that. So it's not something that employers should be taking lightly or just brushing under the rug and trying to dismiss, which it seems like in Megan's case, that's what's happening. So definitely want to give us a shout because there does seem to be a lot there, and you can have a lot of options as far as how you want to proceed with this particular case. If you want to stay there, maybe try to work out some accommodation, or potentially leave and get your severance and then some. So you may have some multiple options there. I've got another question in from Rhea, who's saying that their manager replaced their full-time non-union management position while they were on a sick leave. Then when they returned, they said, oh, I didn't think you would return. They give this person a temporary job and then let them go right before the raise. So yeah, another situation, that looks like bad faith. Normally you go on a leave, you have general job protection. So not to say that you're guaranteed by law to go back to the exact position you had, but you either typically have to go back to the role you had before you took the leave, or go back to a role that is very similar to what you had. If that doesn't happen, then that could be on its own a failure to accommodate and a potential violation of the Employment Standards Act. So there's probably an issue right there. Saying that they didn't think you would return, I guess it depends on how long you were away for, but you say it's a short-term leave. So that doesn't really match up either. It'd be one thing if you had been away for 5 years and no one had communicated with anyone for that period of time, perhaps, but saying that they didn't think you would return after a short-term leave, they're not going to really get much traction there. And then to give you a temporary job, I don't know the details of that particular job, but to then let you go right before a raise, again, suggesting bad faith. So, you know what, much like in Megan's case, it looks like there's a human rights component here. It looks like there's a possible I was going to say constructive dismissal, but they actually let you go. So it's just an actual dismissal. So you could be looking at, much in terms of severance plus human rights. So I definitely schedule a consultation with our firm just to kind of go through all of those details and just make sure that you know what the path moving forward is and to kind of best protect yourself. But I appreciate your question, your comment, Rath. Thanks for that. I've got another one in from Marcus who's saying that they're on probation and their employer fires them for no reason. Does that mean that they're not entitled to any notice whatsoever? So it's a bit of a misconception. A lot of people think that as long as you're let go within the first 3 months of your employment, because you're on this probationary period, that you're not entitled to severance. But in a lot of cases, that's just not true. There have been a lot of cases where someone was with a company for not even 2-3 months, just weeks, maybe a few weeks, and they're let go and they're deemed to be entitled to severance. So, there's got to be something in a contract that specifically says this is a probationary period. Within this period, within 3 months, we can let you go. If we do that, we don't have to pay you anything. So there's got to be specific language in the contract, if there is one, or an agreement you have with the company that spells out how long the probationary period is, what happens if you're let go in the probationary period, and then only then, depending on how it's worded, can a company avoid having to pay severance if they let you go during probation. But I've looked at many contracts and most of them don't have that type of language in the contract. So again, even if you're there for 2, 3, 4 weeks and you're let go, if you're owed severance and there's nothing contractually kind of holding you back, and I've seen people with 3 or 4 weeks of service with a company get several months of severance. So again, it's a bit of a misconception. You may not be owed much, but there are those cases where you could be looking at several months of compensation, even by being at a company for a relatively short period of time. So don't assume that, but also, Marcus, give us a shout and we can advise you 100% kind of what way to go. And just got a follow-up from Rev who's saying they're speaking to HR about ill treatment towards them. Mentioned that if I didn't get a similar job once the temp ends, I would retain counsel the week after I was let go. Okay, so I guess they've been put on notice, but I would still give us a shout and just hold off from any communication with the employer right now, just so that we can make sure all the right things are being said. And it seems like you're also alluding to a failure to investigate, being a person of color. So yeah, there's a lot going on, I think. So to be fair, having a consultation, 30 minutes to an hour, we can kind of cover most, if not all of this. And as I say, just make sure that if you are going to get a lawyer involved and try to negotiate a package or go further, that, we do all the steps needed and kind of set you up for the most success moving forward. So give our office a shout. But again, I do appreciate the question, the follow-up comments. And with that said, that'll actually do it for me today. That'll be my time. But for those that I didn't get around to answering questions of, we do this thing almost on a daily basis. So you can log back in for another session with Mr. Samfiru himself, as you see down below there, this Wednesday. So just 2 days from now, 1 o'clock Eastern. He'll answer all the questions within the time he has as well. But thanks for being with me, for getting those questions in. I do appreciate everyone, and have a great rest of your day.